In this podcast, Pepper partner Greg Nowak is joined by fellow partners J. Dubow and Ivan Knauer for a comprehensive review of SEC and FINRA enforcement activity for 2015. They also take a look at what to expect for 2016. We hope you enjoy this podcast.
This is Greg Nowak from Pepper Hamilton in New York. I'm a partner in the financial services group at Pepper and a co-leader of our hedge funds practice group, as well as our peer-to-peer and marketplace lending initiative. Joining me today are two of my distinguished partners in our litigation group. First, we have Jay Dubow. Jay, why don't you tell us a little bit about yourself?
Sure. Good afternoon, everyone. Former branch chief in the SEC's Division of Enforcement way back when. I've also served as a general counsel and represent now, been for a number of years representing parties involved in the SEC investigation, FINRA investigations, State Attorney General investigations, as well as doing a number of internal investigations on behalf of clients.
And also joining me is my partner, Ivan Knauer. Ivan?
Thanks, Greg. I am co-chair, along with my partner Jay, of Pepper Hamilton Securities and Financial Services Enforcement Group. I also spent some time in the enforcement division at the SEC in the home office in Washington, and spent a second tour of duty with a regulator in the senior staff of the enforcement department at the NASD, and then FINRA in Washington. I do similar types of work that Jay does: SEC investigations, FINRA investigations, state regulatory, internal investigations, securities litigation, and those types of things.
And just to put the three of our practices in relationship to each other, we often describe the enforcement and the regulatory practices as two sides of the same coin. I'll work with clients in developing their policies, their procedures, in dealing with SEC reviews, but when you get the Wells notice or the thundering that normally announces a Wells notice is coming, or some other form of enforcement action, that's when Ivan and Jay and their troops are brought in. And, we work very closely together because obviously avoiding the enforcement is in the best interest of our clients, and we always try to do our best to avoid that if possible. As Emily said, there are presentation materials which you should have access to. We encourage you, please, to ask questions during the course of the presentation. We have an hour or so, and we do want to address them along the way as opposed to at the end. We find that an interactive presentation makes it more interesting for you, and also the last thing we want is for you to hold on to a question until the very end, forgetting and missing everything else that we say in the middle. So, on to the presentation. On slide 2, we have the presentation overview, and generally we're going to focus on recent enforcement efforts by the SEC, some actions against investment advisors, what we're seeing out of the Department of Justice and the SEC's recent focus on wrongdoers, some practice recommendations for executives, directors, and chief compliance officers. Going to slide 3, this is an attempt to lay out some statistics and what exactly we're speaking of when we hear that the SEC has pursuing a broken windows approach to enforcement, a significant uptick in independent enforcement action, roughly the same number of delinquent filings, but overall total actions are up, and disgorgement and penalties ordered is also up significantly from 2013, but not so much from 2014. So, Ivan, what are we supposed to make of these statistics and results? How do you read the tea leaves here?
The tea leaves are that the SEC and the other regulators are getting more and more aggressive as time passes. As the saying goes in Washington, never waste a good crisis. In the wake of the financial crisis, additional rules and regulations were passed. There's been a consistent drumbeat against investment banks and securities firms and hedge fund advisors, and now also private equity advisors, and I think there's more to come.
So let's put this in context, Jay. Before our program, during our prep session, we were talking about the focus, it appears, of the SEC on private equity as a class, with a lot of the enforcement cases being brought against private equity managers, the ones we're going to be talking about here. Is it just because they're capable of fighting back? Is it the abuses that they're seeing? I mean, again, some prognostications and reading of the tea leaves there. Why should the SEC be using limited resources to go after entities that presumably have investors who are high net worth individuals and institutions, people who are capable of protecting themselves?
Well, I think first, a lot of these entities, these private equity firms and hedge funds and related entities, as you know, were relatively recently required to be registered and subject to examination. And as a result, many of these entities are new to this whole regulated regime. And so, while some of these, as we'll talk about some of the cases, some of them are clearly, wrongdoing, intentional wrongdoing. Some of them, I think, are people and entities who who may be more inadvertent, and they're being caught up in these in the investigations, beginning with in many cases examinations. Again, for the very first time for many of these entities, they just weren't used to being in that kind of regime.
So that's an interesting point, and actually a good segue. Just to remind everyone, up until Dodd-Frank, when managers to private funds over certain dollar levels were required to register, for the most part, private equity managers never registered with the SEC because there was the 15 investor rule, and if you were under the fifth number of investors, you didn't have to register. That all changed when that rule was repealed as part of the Dodd-Frank response to the Wall Street meltdown of 2008 and 2007. So all of a sudden, we had entities that were not used to federal regulatory scrutiny or even state regulatory scrutiny, and the only scrutiny they ever really had were litigation brought by their investors. Now, I remember my con law. I mean, the U.S. Constitution says you can't have a bill of attainder, and you also can't have an ex post facto law. So, let's blue sky here a little bit, guys. Here we have a change in the rules that brings these people into a regulated regimen, but they had contractual arrangements in place prior. Do we have an issue? Is there a constitutional issue that people aren't talking about? Or is it something that, it just is what it is?
Well, when you look at the sequence of events, Greg, we have a stack of cases and examples that we're going to go through today, which I believe are all from 2015, right? And if you think about the sequence, you had the crisis that was not wasted in Washington. You had then regulations that required the registration by certain entities that did not ever have to register before. There was much gnashing of teeth and complaining and grumbling about that, but ultimately the SEC is the 800-pound gorilla, and they got to say, if you're going to manage money like this, you need to be registered. So entities that hadn't previously been registered or weren't registered to the same extent became registered, filed their Form ADVs, they became registered investment advisors, and thereby subjected themselves to OC, the Office of Compliance Inspections and Examinations, which then proceeded to do what it does, which is to send troops of examiners into people's offices and ask them for detailed documentation, and they spent a lot of time learning about the private equity industry and the hedge fund industry that they didn't really know about before. And in the course of doing that, so you have the registration, which leads to examination. Sometimes they found stuff that they didn't like, which leads to investigation, and then ultimately leads to an enforcement action. And many of the actions against larger entities that are now registered end up being settled. So during the context of a settled, to get back to actually answering your question, if you're going to settle an investigation with the SEC, you're unlikely to raise constitutional issues because you're not fighting yet. It's a very interesting point, and I don't know actually how a court would end up ruling on that, but I think there's been enough found by the SEC for its examination and enforcement efforts that happened after the law was passed to justify their efforts and to support the settlement.
Yeah, and I think, one theory that I've heard espoused is that, yes, the contract may have been signed at a time when the rule said you couldn't do X, Y, and Z. However, the taking of a fee, for example, is one of the examples where they seem to be highly focused these days, occurs every year. And that every year it's a new violation, and therefore the violation is occurring after the law made the activity inappropriate. So I don't know necessarily if a court would agree with that, but I think if we're looking at enforcement actions with respect to activities that were prior to, it's definitely something to be considered. But anyway, on slide 4, so what have we seen from the SEC? Well, they've created an asset management unit within the enforcement division focused on asset management, and that includes both hedge funds and private equity funds. Not so much venture capital, because if you'll recall, pure venture capital managers were excluded from registration under the Dodd-Frank Act. Enhanced expertise in both hedge funds and private equity. They went out and actually bought people who knew what they were doing and brought them on board. Increased use of technology. Big data used to scare the SEC, and they would ask us to cull before information was delivered. Now everything has to be delivered in its native format, and they do the culling because they believe their algorithms are suited to that. So previously, hiding in plain view, the Raiders of the Lost Ark approach to responding to SEC enforcement was a strategy that some people imposed, not anymore, because the bigger the data, actually, as long as you have a good number cruncher, you can figure out trends, and that can lead to further enforcement action. The SEC created the whistleblower program as part of the Dodd-Frank initiative, and they also expanded enforcement actions. This is from the SEC Enforcement Division. They now liaise more completely with the regulator, the Investment Management Division. Going to slide 5, we've had a number of enforcement actions previously, of types previously not seen. So we have cases involving receipt of unauthorized or inadequately disclosed fees. Whether or not it's inadequately disclosed, of course, is in the eye of the beholder. In this case, the SEC is the beholder, and they're the ones who say that it's never adequate in certain circumstances. Cases involving expenses improperly charged to funds when the advisor should have borne them. These pop out because they tend to be pretty egregious, and we're going to go through an example or two of those. Cases involving more profitable trades allocated to advisors and less profitable or losing trades to clients. It is a known fact that the instant that a manager takes his second client, he creates a conflict of interest between those two clients, and he needs to have policies and procedures in place, trade allocation algorithms and mechanisms that make sure the investors do not get harmed because of his trade opportunity. And if the manager is also co-investing, the manager needs to take extra special care to make sure that the investment opportunities being presented to the investor clients are not second tier to those being taken by the manager himself. Traditionally, that has always been solved by the hedge fund world by requiring the manager to invest in his fund and then essentially eat his own cooking and receive the same return as the investors coterminously with the returns that they received. Private equity hasn't quite worked that way because the assets tend not to be liquid. Improper valuation of illiquid assets. Again, a huge issue. We're just seeing the tip of the iceberg on that. Cases involving inadequate disclosures of conflict of interest. And all cases, however, seem to share a common theme, which is a violation of the advisor's fiduciary duty. If you'll recall, a few years ago, Congress wanted to merge broker-dealers and investment advisors and essentially create one standard. Well, that really doesn't make sense, at least historically, the way advisors and broker-dealers tend to operate. We always teach our young associates that an advisor has a fiduciary duty because he makes 3 decisions every day, all day. The decision to buy, the decision to sell, or the decision to hold. Decision to hold, of course, is an investment advisory decision, and that's why there's a justification for an advisor to be paid based on assets under management. A broker-dealer, on the other hand, doesn't assume that decision to buy, sell, or hold, but rather is charged with best execution, to be the true agent getting the best possible price for the principal. That's a very different function and a very different duty. And so merging those concepts, it would be virtually impossible. But for purposes of our discussion today, when we're focused on fiduciary duty, we need to understand what that is, and we do need to understand that it raises its head at times where people don't see it coming. So we're going to turn to our first case, which was on slide 6, which is the recent SEC settlement with the Blackstone Group. Ivan, why don't you tell us what happened here?
Happy to. Apologies, first of all, to anyone on the phone who may be affiliated with any of these entities. That's been known to happen, and they are all public. We're going to do our best to explain. As Greg said, these cases against investment advisors have one thing in common, which is that there is ultimately alleged a violation of the advisor's fiduciary duty. And this duty was first set forth by the Supreme Court. It's contained within the Investment Advisors Act of 1940, but the Supreme Court confirmed that in a case in 1963 and in many other cases since. For general consumption, a fiduciary duty essentially means you got to place your client's interest ahead of your own. You're not supposed to take fees without disclosing them. You're not supposed to take gains that your client is supposed to get, and you're not supposed to benefit yourself to their disadvantage. There is a great old case from New York State by then Judge Cardozo before he became the justice on the Supreme Court, who referred to the fiduciary duty as the punctilio of an honor the most sensitive. I have no idea what that means, but it's really, really serious, and it's a very high standard. You never want somebody to be holding you to the standard of a punctilio of an honor because it's really hard to comply with it. So having said all that, the Blackstone Group had to do with the fact Blackstone is now acting as an investment advisor. It's managing a pool of money. That pool of money is obviously raised from investors who buy, into the fund. The advisor, Blackstone, also then charges a monitoring fee to the public companies that advise, which is disclosed. And then when there's an IPO or a sale of that company, those payments are accelerated, and the payments go to the investment advisor, not the fund, and that's not disclosed to the investors.
But in this case, there was an acceleration of that. There was an acceleration. Because of an IPO of the underlying company.
Right. The monitoring fees were supposed to last for a certain period of time. And then, say there's a 10-year term, and the company goes public, and there's a liquidation event, if you will, after 3 years. Then the remaining 7 years are accelerated. Those payments go to the advisor, not back into the fund, and that was the problem that the SEC ultimately saw with this. It's under the concept that you can't benefit the advisor at the expense of the fund or its investors, technically without disclosure. Now, they always say that sunlight is the best disinfectant, right, and that the primary goal of the securities laws are to promote disclosure. I'm not so sure the reality of that, how it plays out in some of these cases, because there is some lip service that is paid, that certain disclosures were made to a point, but then it was that final disclosure that was not sufficiently forthcoming. And sometimes I find that in enforcement cases, even if there is sufficient disclosure, it may not be done in plain English. The staff may not like it. They may not think it's completely fulsome. It may end up just being, somehow deficient in the minds of the enforcement staff. And once you're in that situation, you have to now prove the negative and prove that you've complied with your fiduciary responsibility.
Yeah, and in the summary of the case that the SEC published, it says Blackstone failed to disclose to its fund and to the fund's limited partners prior to their commitment of capital that it may accelerate future monitoring fees upon termination of the monitoring agreements. So there clearly was disclosure that they were taking a monitoring fee, and the limited partners knew that. It's standard practice, at least at the time. But the issue was that a fee that otherwise would have been paid had there not been an IPO was pulled forward and accelerated and charged to the fund and paid to the manager, and that's what seemed to have gotten in the SEC's crawl.
Right. And that was one thing. The other issue in this case is something that is a little bit, interesting from the perspective of law firm, which is that Blackstone had negotiated basically a single source arrangement with a law firm that is not identified. Don't know who it is. If I did, I wouldn't say it. But they worked out an arrangement where they got discounted fee for the advisor. And the fund itself paid, also the same law firm, paid full rates, or at least a higher rate.
Well, it says here, received a discount that was substantially greater than the discount received by the fund.
Right. So whatever the standard, normal, and reasonable legal fee was, the fund got a discount of X, and the advisor got a discount of some multiple of X. And this is an example where the staff looked at this and, there was a sequence of events. There was an internal compliance review, then there was an OC examination, then ultimately people figured it out. And Blackstone, being good corporate responsible citizens, when it was pointed out, they ultimately didn't fix it. But the issue really was, here you are, the advisor is getting a better deal on legal fees, on services that it's paying, than the fund is. And that was perceived by the staff as a breach of fiduciary duty because the advisor is benefiting itself and not passing those benefits on to the fund.
Well, and there's also the statement that Blackstone did not disclose the disparate legal fee discount the law firm provided from 2008 through early 2011 to the fund's advisory council, or the fund's limited partners. Because of its conflict of interest as the beneficiary of the disparate legal fee discounts, Blackstone could not effectively consent to the undisclosed practice on behalf of the funds. Now remember, in a fund context, especially a limited partnership where there's a general partner, the only person who under state law has any right is the general partner. He's the only person who has legal authority to do anything. And what they're saying here is because of the failed disclosure, Blackstone's ability to consent on behalf of the fund was hampered and hogtied.
And now it's a conflict of interest.
And now because of the conflict of interest. That's right. So,
right. Now, again, these cases are all done in hindsight, right?
Right.
I mean, if Blackstone had made the decision that it was going to share the same discount with the funds that it got itself as the advisor, there probably wouldn't be an enforcement case because there would be no reason for it.
On that issue.
Right? Because they would have done the right thing. Mm-hmm. And no one would have looked at it and said you had a conflict when you made that choice because you did the right thing, and no one would have seen it. Even though they might have had a conceptual conflict, they did the right thing. And I couldn't see the enforcement division bringing a case on that if there's no harm. The old no harm, no foul. Jay, don't you find that to be the case?
Yeah, although, look, I agree with you. I mean, you never know, though. The enforcement division could have taken the position, well, the reason you got the benefit was because of the legal fees that the fund was paying, and therefore the advisor shouldn't have gotten the benefit of that discount. But I agree that if it was the same, it probably wouldn't have been an issue. Here, just because of the disparate treatment, I think made it something that certainly when you add it to the other issue, that they were looking at, that makes it more interesting to Division of Enforcement.
And that's actually a very interesting observation. Taken individually, neither of these things seems to be the kind of, fiduciary violation that's going to cause the ire, but I think it's probably the combination that, caused them to refocus on it.
Yeah, I think that's right. And I think as I said at the outset when we were talking, some of these things are because firms were not used to being in a regulated environment. The conduct here is very different than some of the conduct we're going to describe in some of the other cases.
Right, that's right. And Greg, they do make distinctions, and when you read through the cases and you focus on them, you start to see the distinctions. The Blackstone case, and we'll talk about the KKR case in a minute. There was a fine that was imposed, a $10 million fine, which doesn't seem to bear any relation to anything. It seems like the staff said, you're a big entity, this is a bad thing, and we're now going to pushed out across the bow, so it's a $10 million fine. But there was also, in the Blackstone case, a $30 million disgorgement that was required to, basically, the advisor had to effectively figure out a mechanism to repay the investors. In that case, as well as I believe the KKR case, in the order instituting proceedings, the staff also recognized cooperation and expressly said that it appreciated the cooperation that was provided. And also in both of those cases, and this is part of the currency that you deal with when you're dealing with staff, no individuals were named. No individuals were named in either of those cases. And also the quote-unquote fraud under the Advisors Act 2062 and 2064, they are non-scienter-based fraud. So they don't require a level of intent to deceive or recklessness. So those are things that when you really kind of look at the nuances, you find that yes, they did things that they shouldn't have done. No individuals were named. No scienter-based fraud. There was a penalty, but it's a modest penalty for an entity like this, and there was a certain disgorgement.
Yeah, and just I want to note, the settlement, the entity did not admit to any of the allegations. There's no
Correct.
admission. Yeah.
There's no admission. It's neither admit nor deny.
Right.
All right, so let's talk about KKR for a moment. This is slide 7. Ivan, you want to give us the quick facts on this one?
Sure. As is common in the private equity industry, the folks who work for the advisor are the ones who are going out looking for deals. They're looking for situations that they could cause the fund to invest in. Many of those don't pan out, and they result in expenses for deals that are dead. They refer to these as broken deal expenses. Ultimately, those are supposed to be allocated, appropriately across, the investors who invest in this entity, the fund, and also the co-investors who invest in
That's the problem. It wasn't the fund.
It was the
It was the fact that they did not adequately disclose, that KKR did not allocate broken deal expenses to the co-investors, even though these vehicles participated and benefited from KKR's general sourcing of the transaction.
Right. Now, and it's important, I think, to realize, although, it's not glaringly apparent until you drill into the document, but co-investors include executives, consultants, people who are potentially closely related with the powers that be at an entity like this. And it just happened to be the case that those investors were not charged the broken deal expenses that the fund was ultimately charged.
So
the way this plays out, if you sort of bring it back up to the generic level, it's a violation of a fiduciary duty by the advisor because they favored one set of investors over another, and it just so happened that set of investors that got favored are somehow individuals who may be affiliated with the entity.
And don't you think that compounds the issue?
I think it ultimately does, although once again, it was a non-scienter-based fraud. It was a 2062, which can be done by showing of negligence, scienter or intent. There was a $10 million fine. Cooperation was recognized. No individuals named. There was an $18 million disgorgement that was ordered. And another thing that was similar about this case and the Blackstone case and the other cases is that there's a sort of bootstrapping that goes on. Once they get you with a violation of something, it's not only a violation of 2062, it's a violation of 2064, which is another type of non-scienter fraud. And then you get thrown in, you get dinged for failing to have appropriate policies and procedures to prevent the violation, right?
Or detect it and remedy it.
Exactly.
Right. So you're supposed to not only prevent the violation, but also have the policies and procedures to detect and remedy.
Whether there would be a case simply for not having the policies and procedures, if the bad thing, quote-unquote bad thing, had never happened, that's a different question.
Another way to look at sort of a common thread between both Blackstone and the KKR cases are that we have, in essence, a disguised fee. In the case of Blackstone, it was the discount, and in the case of KKR, it was the fact that essentially the private co-investors got a free ride. They didn't have to bear the broken deal expenses, which were being borne by the underlying fund.
Right.
And now the real question is, had all of this been disclosed, would the SEC be making the argument that the disclosure in advance, when the investor becomes an investor in the fund, is not sufficient disclosure and not close enough in time to when the broken deal expense is being allocated 2, 3, 4 years later, it's not adequate disclosure at the time?
Yeah, in theory. Yeah, in theory, right? Disclosure cures all in the securities world. One could, hypothetically, say, disclose to people in your offering memorandum or whatever, we have no idea what we're doing. We're likely going to lose your money. We're going to charge you lots of fees. We're going to allocate all the good stuff to ourselves, and we still want you to invest in our fund. And if they do that in plain English and people decide to invest anyway, presumably you're insulated. That usually doesn't happen. Right? In the cases staff drills into it, they see that people are making a lot of money for doing this type of work. And anytime there is something that is not completely equal and in their view above board, they are going to look to bring a case. And it's never, if you see the prefix miss ever applied in a case, generally it's not going to turn out well. Misallocated, misapplied, misappropriated. In KKR, they misallocated $17.4 million in broken deal expense. You don't want that miss prefix anywhere near you.
All right, so let's turn to slide 8. And this is one, I can't tell you how many times in 2008 and 2009 I was getting calls from managers saying, I was never required to register before, and now I have to register. It's going to cost me X dollars. Can I have my fund reimburse me for that? Of course, the answer always is no, because it's not the fund's registration.
Someone didn't get that answer.
I'm sorry, but Cherokee Investment Partners did not call Nowak before they made this decision. And again, it's when you look at the facts, ultimately it becomes sort of a simple case, right? It's the advisor that is required to register. Okay, yes, to manage a fund, you need to be registered, but it's not the fund's fault. In other words, it's not the investor's fault that the advisor now has to register. The advisor should, in the views of the regulators, be paying for those expenses. And so when you misallocate, there's that miss again, when you improperly allocate the legal fees and expenses required to register the advisor to the fund, you are depriving the fund investors of that money, and that's violation of the fiduciary duty, and that's going to be, once again, it's a breach of fiduciary duty, but it's a non-scienter based violation of 2062 and 2064, and again, the bootstrapping to the compliance rule of 20647, cease and desist order, $100,000 fine, but again, no individual is charged.
But what's important to keep in mind here is when you read the summary of the facts, it wasn't just for registration as an advisor. It was registration as an advisor, complying with legal obligations arising from registration, including preparation for examination by the staff of the SEC, or responding to an investigation of the respondent's conduct by the staff. So basically, there were 3 violations here. There was the violation, the fund shouldn't have paid for the advisor's registration costs. Then the SEC staff came in and reviewed the advisor and presumably the fund, and they charged fees for the advisor's review to the fund.
Right.
And then the last part being the response to the investigation.
Right. Now that's an interesting distinction, right? That requires some thought as you're getting into the registered world. The advisor to a fund is not the same thing as the fund. Right? Here you have examinations going on of the advisor, whether they comply with their responsibilities towards the fund. It goes fiduciary duty to the fund and the fund's investors. In a different context, for example, if it were, say, a mutual fund, which is also issues stock, right? It's a 33 Act company as well as a 40 Act company. It does occasionally happen that mutual funds get sued in a class action, right? Now, that is a suit against that company. And under those circumstances, I believe it would be appropriate for the fund to pay for defense either through insurance or directly, of the action where somebody is being counseled for the fund. In the 40 Act world also, I think fund counsel is actually paid for by the fund.
By the fund.
Right?
So, the
advisor gets a fee to manage them.
Yeah, so let's talk about a couple of different unique circumstances. A fund decides that it's time to draft or redraft its offering circular. Clearly, redrafting an offering circular for an open-end private fund like a hedge fund would be a fund expense, not an advisor expense.
Correct.
However, a private equity fund that chooses to open Fund 2 can't charge the cost of drafting the documents for Fund 2 to the investors in Fund 1.
Right, correct.
Because that would appear to be something that would have to be charged to Fund 2. Now, it may be fronted and reimbursed to the advisor at a later point in time, but it clearly is a Fund 2 expense.
You mean loaned and appropriately documented.
Yes, yeah, or advanced. Advanced. Because the advisor is in fact a promoter for the fund, and so therefore they would advance those costs, expecting reimbursement from the fund once the fund is filled with investors. So there are legitimate expenses that should be charged to the fund. As you said, litigation, deal expenses, probably even broken deal expenses.
Correct.
Could arguably be charged to the fund, unless, of course, you have co-investors or someone else who's participating.
And the broken deal expenses could have been charged to the funds. There was a rebate arrangement, effectively. What happened back in that case was that the co-investors were not included, and there was no disclosure to everybody saying, effectively, we're going to favor our co-investors over the fund. Right.
And one of the other things that, oftentimes the staff is incredulous about is, well, why would a manager not charge legitimate expenses to a fund? Well, it's in the manager's best interest to absorb some of those expenses because it hits returns.
That's true, too.
And so then you have another question of whether or not in those circumstances where it's a quote-unquote legitimate fund expense, if the manager is a good guy and absorbs that expense, is there a further disclosure issue that somehow, some way, the return is not a true return? Because an expense has been shifted from the manager. So it truly is a Goldilocks world, right?
Absolutely.
Can't be too large, can't be too small, can't be too hot, can't be too cold, and everybody has to pay his own.
Yeah, and in that situation, I mean, if it had a material impact or any impact on performance, that's whether I think in those circumstances, the advisor would probably want to get credit for having, absorbed some of those expenses, so they would disclose it for advertising purposes, if you will, for no other reason. But whether they had a responsibility to do it, that's an interesting question. Probably if it would have a material impact.
So let's shift gears for a moment away from the fee world into the cherry-picking world and the Wellhouse Associates, Inc. case.
Right. So now you get into a case where there's actually a person who is doing a bad thing. This is sort of an old tale in the advisory world where you have an advisor who has personal accounts or may have a performance fee-based fund and a non-performance fee-based fund, and for whatever reason, the advisor does not custody the assets. They have a broker. They have authority to make the buy and sell. In this instance, they were doing option tradings of spiders. And they do a bunch of trades, and at the end of the day, he would look and see which ones won and which ones lost, and lo and behold, the winners were allocated to the advisor's personal accounts in a way that benefited him, and the losers were allocated to the customers. This is a heads I win, tails you lose situation, and if the staff of the SEC ever learns about this, they're going to bring a case.
But hold on a second.
Yeah.
How is it possible that these trades were not allocated immediately because the trade was executed, presumably, order against a ticket? So this would only arise if the advisor is purchasing these trades in its own name and holding them and then allocating them to the investor buckets at the end of the day.
Right. Here in the respondent's conduct section, they're talking about how the individual made trades in a master account at the broker and later allocated the trades to either his or his client's account. And he, this is once again a bootstrapping situation, right? First of all, it's a 10b-5 and 2061 violation, so it is a scienter-based intentional fraud charge. Then you have a false ADV charge because he disclosed in his ADV, as many sort of smaller advisors do. They take an off-the-shelf one and say their allocation is going to be pro rata, and then of course they don't follow the pro rata. So not only have they committed fraud by stealing the good cherry picking from their clients, but they also have a false ADV charge because they didn't disclose that they were going to be cherry picking their clients. Again, in theory, if he'd done this bad thing but disclosed it in his ADV, there might not have been a charge.
Well, I don't know about that.
But I don't know about this one.
For the ADV. No, for the ADV,
but not the conduct.
Yeah,
absolutely.
But I got to tell you, the bigger issue here, again, not looking at it after the fact, but in a planning stage, is this whole idea of the master account and whether or not a advisor is well advised to essentially be running a private fund, because that's what that account is.
Right.
Well, but theoretically, that advisor has a fiduciary duty. And the advisor is going to execute and fulfill his fiduciary duty by appropriately allocating those trades and by conducting the trades in a way that's most efficient and gets the best execution.
Or not putting them into an omnibus account and rather purchasing directly in client A's account, client B's account, client C's account.
Now you have another situation, right? Which ones do you do first? You have a stock that's moving very quickly. You go to investor A, B, C, and you do it in that order, and the stock has now moved.
If you use a randomization vehicle, I mean, there's a lot of different policies and procedures in place. This has been around a long time.
And to Greg's point, once it's, when you put them in that master account, you're putting yourself in a position,
correct,
of
picking winners
and being accused of what happened here.
Absolutely true. However, in the real world, if you're managing a big enough fund and you're buying, 100,000 shares of Apple,
right?
If I'm managing one fund, I don't have an issue. The issue only arises if I have separate accounts.
Well,
and I'm doing allocation.
And you're doing allocation. Right. You have a lot of different accounts. You have a lot of assets under management. You're buying a lot of stock. You'd spend all day just trying to get those orders.
Well, here in this case, though, too, his story about how it was it was an accident, or they just didn't ring. I mean, it compounded his problem.
It was an accident.
Yeah.
This is a reminder of what Jay and I tell our clients on a regular basis. The one most important thing to remember is always tell the truth, because if you don't, you're just going to dig yourself into a deeper hole.
All right. We do want to get to the Yates memo and some other things. So we're very quickly, Ivan, two or three sentences on the next three matters.
Alpha Bridge had to do with overvaluation of assets in a portfolio. Again, an old story, right? Fund advisors charge for their fees based on assets under management. If you overvalue the assets under management, you're paying yourself more fees than you should. If individuals are involved, they're going to get charged. In this instance, the worst individual who's involved actually got barred from the industry.
Yeah, but what he did, and this is the important point, is he was putting the fig leaf on the fund that he was getting independent price quotes from broker-dealers, when in reality, he was feeding these price quotes to the dealers to pass off as their own.
And coaching.
Right. And coaching the dealers.
Particular broker in his conversations with compliance and with the auditor.
Right. And so, when you're dealing with illiquid securities and you're saying, I'm going to get an independent price quote, it darn well better be an independent price quote. Right. Or you have to disclose, we're going to use a manager mark, and here's the reason why a manager mark in this particular instance is appropriate. Or you have to use a different structure. And to accommodate those structures, we use the terms a closed-end private fund or an open-end private fund. Mm-hmm. If you can't value that portfolio with a degree of certainty, you should not be using an open-end structure.
Right. And the particular securities issued here were interest-only and inverse interest-only floaters, which were a tranche of a collateralized mortgage obligation, and the price of those in the marketplace was declining rapidly as interest rates came down and people were paying off their mortgages faster. And it's in a situation like that where the fund advisor doesn't like to see the assets under management go down, that they sometimes are tempted to fudge them in ways that are not ultimately appropriate.
Okay, so Fenway, slide 11.
So here's in some ways similar to what ultimately happened in KKR, although much more sort of intentional. There were investment advisors to private equity funds had agreements with the portfolio companies to provide certain services for money, and then it would offset that money against fees paid by the fund to the advisor. Some individuals who were associated with the advisor actually created a separate consulting entity and shifted the contracts to that entity. So effectively, the same individuals got paid twice without any rebate being given. So you had the advisory fee being paid to the advisor and the consulting fee being paid to the consultant, no rebates, and so it was effectively overcharging, and that's a violation of conflict of interest, violation of fiduciary duty. Nobody was barred, but individuals were fined, and it was enter-based fraud, and the company was fined as well. And that was Fenway.
And we're going to skip over slide 12. We're going to deal with that when we get to slide 17. So, Jay, tell us about the Yates memo. We're on slide 13 for those going along.
Many of you may have heard the Yates memo is something that came out recently, September, and it is a memo from the Department of Justice, Deputy Attorney General Yates, and the focus of the Yates memo is on the Department of Justice and its investigations to make sure that individuals are being looked at very, very hard. And it's a result of a lot of criticism leveled against the government that with all the financial fraud cases that were brought out of the financial crisis, very few individuals were even named in many of those investigations. And so it appears that this was an effort to really do a number of things in terms of individuals. And just by way of an aside, this theme of individuals and being held accountable was something that the SEC, through its chair and its director of enforcement, have been touting for some time as well. I mean, they've been out there making speeches that were focused on individuals for some time. And I'm going to talk a little bit more about the Yates memo in a moment, but for those of you who want to do a deeper dive, if you go on Pepper's website, we did a client alert on this, a few of us, when it not long after it came out, as well as we expanded that in last month's Insights magazine was a link on our website to it with a little even more detailed article on this.
But this is, first of all, let's make sure everybody understands, this is a DOJ memo,
correct,
not an SEC memo.
That's correct.
Number one. Number two, it's not focused or directed at funds or investment advisors. This is for essentially the SEC in administering the public markets and broker-dealers and everybody else, correct, including advisors and funds.
Correct. This applies across the board.
Okay.
And again, it's the Department of Justice, so that would involve both criminal and civil investigations that are done by the Department of Justice. And again, as I said, the SEC has made similar comments and speeches at senior levels about making sure that individuals are responsible. So, if you look at slide 14, the Yates memo had 6 main sort of factors and issues that they wanted to be addressed. And the first, which is that, many companies come to the government and they they cooperate, as you saw when Ivan talked about some of the cases, they noted the cooperation credit. But according to the Yates memo, companies are to get no cooperation credit at all unless the individuals who were involved and at all levels are identified for them. So, as Ivan also noted, a number of those early cases that noted the cooperation that he talked about there were no individuals named in those. So it's important, again, if you're going to cooperate with the government to get full and to get any credit now, according to the Department of Justice, one needs to identify names. Then the second point of the Yates memo is that this is really a point made out to the department, to all their offices and assistant, to all the U.S. attorneys, that there's that all investigations by the Department of Justice and joint investigations must target individuals at the outset, not wait to the end as an afterthought. And both the criminal and civil counterparts, they want them to share more information about individuals, which raises a question. And certainly the civil side can always share with the criminal side. Criminal side, if they get materials pursuant to a grand jury subpoena, by law, are not allowed to share that information. So by putting this out there, it creates potential issue if in fact there's some slippage there.
It used to be the way, Jay, it used to be sort of an understood thing that in at least an SEC investigation or a FINRA investigation, a company could decide it's going to pay up a little in the penalty in exchange for basically the staff agreed not to name an individual. Does that work anymore?
Well, in fact, you got to the next bullet. And the next bullet says precisely no. That's one of the specific matters, that the DOJ will no longer accept larger fines in lieu of charging individuals.
What about the SEC?
Well, the SEC hasn't said that and hasn't made that formal statement. But again, I think taking the speeches that were made by the chair and the director of enforcement, as well as now that the Yates memo is out there and they've all read that as well, I think there's going to be a lot of pressure not to do that. And which then gets to the last two items on the Yates memo. One is that you can't settle with a company. This is to the Department of Justice, again to U.S. attorneys, unless there's a clear plan how they're going to prosecute individuals. So you can't just, we're going to deal with the company and then we'll just not think about the individuals. And also, the last point is that the Department of Justice will no longer take into consideration an individual's ability to pay for defense or to pay a penalty. And that is just because someone doesn't have money, you shouldn't give them a pass. They want the Department of Justice to charge people as appropriate.
So let's take a step back here. Can a company still defend an individual?
Well, when you say, can they? Many companies have obligations to defend
under state law
to pay for the defense of individuals, right, under state law, for example, advancement of fees. And they may have director and officer liability insurance, which is then an insurance company obligation.
So it's important then to make sure that you have determined that your company's bylaws, articles, or state law require the company to defend you, pay your costs, and also to the extent, you should review your insurance coverage to make sure that you're being able to call the insurance coverage in to pay for these expenses at an investigation stage.
Right. Well, Craig, that's an interesting point. So your comments you just made, who are you counseling? And I raise that because certainly if you're an individual, you would want to have, for example, mandatory advancement of your legal expenses. That would be in your interest, and by the way, most companies have that for officers and directors. If you read their bylaws, they say that they're going, they shall advance, which is separate from indemnification. Indemnification is something that's determined at the end of investigation or litigation or whatever the matter is, because you don't know at the outset whether someone did something wrong or not, whether they're entitled to indemnification. But advancement is a separate concept, whether your legal fees will be advanced. And many companies' bylaws or through contract provide for mandatory advancement. Some companies now do not have mandatory advancement, and it's now up to, for example, the discretion of the board. And so if you have that discretion, that's when the question is, do you advance those legal fees? If someone is a bad actor, and knowing a bad actor, someone who's stolen money from the company, sometimes you don't want to, as a general counsel, be telling the board or the CEO, well, we have to keep advancing this guy's legal fees because we have this obligation.
But time out. But take the normal case here where, there's an investigation by a regulator and companies don't act by themselves. They act through people, right? And under most state law, whatever the individual employee does in the name of the company is going to reflect on, and the master is going to be responsible for his agent's action under respondent superior, however you want to describe it, right?
If it's within the scope of his employment.
Well, yeah. So unless a company can make the argument that, that decision you made to allocate those expenses to the fund was outside the scope of your employment, ipso facto because the SEC says it is, and now therefore I'm not going to defend you, I don't see how the company could step away from liability as the master of the service.
Well, it depends on the fact, Greg. I mean, you could have a situation, company uncovers something bad, some egregious conduct, and they make a decision. Do they want to go to the government and make a deal that's going to be good for the company and maybe not so good for that employee? Okay. It depends on who the employee is and what the facts are. Do they have to, indemnify? Do they have to advance? Those are issues of contract law, bylaws, and state law. You don't have an obligation to advance unless you've stated that you do. Indemnification, you could have a legal obligation because if someone defends themselves and is successful, and under most state laws, then the company would have an obligation to indemnify them. But if they're not paying for the legal fees along the way, maybe they don't win that case.
We only have a few minutes left, and I did want to get to the two recent chief compliance officers. Excuse me, I'm losing my voice here. Jay or Ivan, could you take us through SFX?
Yeah. So. And I'm going to talk quickly. So in SFX, this is actually a case where you had some bad conduct, and you had stealing of assets, misappropriation, and Ivan's misterm. The chief compliance officer, learned about that from a client who complained the client couldn't use their credit card. And so they did an investigation, learned that this bad actor had stolen assets, and then they self-reported that. They went to the government actually and self-reported it. And as a result, they were rewarded for their self-reporting with an action against them, and that said that the entity as well as the chief compliance officer failed to do a number of things. And they failed first to have policies and procedures which were designed to prevent that misappropriation of assets. And then they failed to implement the policies that it did have in place. And they also were falsely stated in the Form ADV that they were reviewing client accounts. The actual disclosure was they reviewed them several times a week, and they didn't do that. And so, and they looked at whether the chief compliance officer, according to the SEC, was asleep at the switch and didn't do anything. And so they censured both the company and the chief compliance officer, and the company had to pay a fine here of $150,000, and the chief compliance officer paid a $25,000 fine.
But he wasn't barred.
Was not barred.
He was not barred.
Correct.
So let's talk now against the BlackRock advisor case.
Okay, and that one, again, this was a one against. There was a conflict of interest here, and here you had someone very, a senior person, a very wealthy person who worked at BlackRock, who formed a number of separate entities, energy-related entities that he and his adult children were owned and controlled, and there were huge conflicts. They were undisclosed, and that was really the issue, the main issue here. There was a lot of that you had these conflicting entities. They weren't disclosed. There was also they weren't disclosed to clients, and they weren't disclosed to the board, and there was a private investment policy which also was violated, and that the violation wasn't disclosed to investors. And this was, again, one where they said not only did the entity, but the chief compliance officer fell asleep, was asleep at the switch, didn't do what he was supposed to do here, and therefore, he was not monitoring appropriately this relationship and making sure that the disclosures were made, and so he was settled and agreed to a $60,000 penalty. In this case, BlackRock paid a $12 million in this case, and they also agreed to bring on an independent consultant, which has a lot of expenses associated with that. So it was very expensive. Very expensive for this. The $60,000 penalty. These are settlements. All these cases are settlements. So, you don't know what would have happened if there was litigation. A lot of times people, want to get things behind them and they agree to things that, you don't know what really would have happened.
But in this case, the real issue was the failure to report up.
Correct.
To report up to the fund's board of directors that a key, highly placed, well-compensated individual had engaged in activity that was a conflict of interest. And then they got the chief compliance officer because he should have known, should have had policies and procedures in place to detect that, and then to kick that information upstairs. So if you turn to slide 18, we've got a couple of quick recommendations, and then we're going to break. Focus on your controls and procedures. What are you doing? How are you doing it? Are they the right procedures? You may have developed your compliance manual and checklist 5 years ago. Your business has changed. The world has changed. You may need to reevaluate, do a risk assessment to determine that you're looking at the right stuff.
On that point, though, let me just add, sometimes people take things off the shelf, or to Greg's point, they have an older one. You want to make sure you have a policies and procedures that are right for your business and that you can and are compliant. You don't want to have something in place that just doesn't work.
That's an independent violation.
Exactly.
Procedures.
Right. Maintain a meaningful dialogue with your outside auditors. They're there all the time. They know what's going on. They can see telltale signs of movement of cash or otherwise. Retain lawyers and accountants for complicated questions. Everybody's budget constrained, but the reality is there's a requirement to get a ticket to the dance. And that requirement is that you have a compliance culture. And nothing is evidence of a lack of a compliance culture than a firm that tries to solve every one of its problems on its own, because this is just too complicated a business and the rules have changed. And so you need to think about when is it appropriate to get a sounding board, a second opinion, because those second opinions can be very invaluable if you end up with an SEC review. If your CCO is an outsourced CCO, you got to review their business practices and make sure the CCO has enough authority to implement compliance programs and policies, and make sure they have regular in-person communication with the principals of the firm, and that they have enough access to documents and information.
Yeah, the SEC has come out recently with some very, very critical of outsourced CCO functions. So this is an area to be very careful in.
And finally, make sure that you and your CCO are indemnified, including the advancement of fees, and are covered by appropriate insurance. Thank you, Ivan and Jay, for your participation today. Sorry we went over a few minutes. Have a great afternoon.